Learned Counsel.
Yes, my lord.
Good
morning, my
morning, Learned Counsel.
Good
Colorful.
morning, my lord.
Yes, my
Sorry
lord.
for coming late.
Good morning, my lord.
I
Thank
had
you.
to get print ruling.
Thank you, my lord.
Good morning. Give me color for color. Okay, appearances.
My lord, we don't know which of the cases.
Appearances. Whichever one, is it not the same appearance? Is your
It's the
cases,
same
your three
appearance, my
cases?
lord. Yes. Yes, my lord. My name is Kolakbo Kolade. Kolakbo
Okay,
Kolade.
thank you.
Yes,
And
my
the
lord.
color for Colade case we are calling. Yes.
And as the copies is,
Color for Colade
I humbly appear for
versus Governor Ekiti State and
Yes.
Sterling Bank PLC.
Thank you, my lord.
Yes.
And Kolakbo Kolade, I appear in person, my lord.
Oh, okay.
I appear for the judgment creditor respondent.
Yes. No, I think the proper announcement is what you did in person. I think so. Because you are the judgment creditor applicant.
Yes, yes, my
You are
lord.
respondent.
Yes, my lord. I'm grateful, sir.
Ruling.
Yes, my lord.
Yes. Although you are the applicant in the Ganishi proceedings,
As the court
but
pleases.
in this particular application, you are respondent. Yes, State Council. State Council.
With profound humility to this noble court,
Yes.
with profound respect
Yes.
to this honorable court, Toluwani Alabi is my name.
Yeah.
My humble appearance is for the judgment debtor applicant. Senior Legal Officer, Ministry of Justice, Ekiti State.
You said your designation?
Senior Legal Officer, Ministry of Justice, Ekiti State. I'm most grateful, sir.
The judgment debtor applicant.
Yes, my lord.
Number one. Disturbing.
Okay, the matter is for ruling.
As the court pleases.
Is that correct?
Yes, my lord.
Yes, my lord.
Tell motion to give you the rulings. Sorry, gentlemen. I took time printing the rulings. I came into court late. In my head, I forgot them in the office.
Oh,
so
thank you, man. Yes, sir.
Meanwhile, before as they bring the rulings, there are 3 rulings.
Thank you, my lord.
Is that correct?
Yes, my lord.
And we are answering the same question in the 3 rulings.
Exactly, my lord.
As the court pleases.
Okay. So that
the answer
when
to
I pass the first ruling, although I will not just say it abides the other ones, we will call the other ones, but I will simply summarize. I will highly summarize.
As the court pleases.
Yes. So this is the ruling of the court. in the National Industrial Court of Nigeria in the Akure Judicial Division holding Akure before His Lordship Honorable Justice K.D. Today is 27th day of July 2021. Suit number NICN /AK/05/2019. Motion number NICN /AK/57M2020 between did you say something? Kolade?
Yes, my lord.
Just the below. Just the below 1,000. Sorry, Kolade, did you say something?
My lord.
While I was reading out, did you say something?
No, my lord, I couldn't hear. The thing went off. It just came back now.
Okay, yes, the network.
Thank you, my lord.
Okay, so this is the ruling and the introduction. This Honorable Court, Per Oyewumi J, delivered judgment in suit number NICN/AK/05/2019 on 18th November 2019 in favor of the judgment creditor respondent for the sum of 5,765,944 naira 16 kobo. The judgment creditor filed a garnishee proceeding on 30th June 2020 for the attachment of the sum of 5,765,944 naira 16 kobo, being the judgment debt plus interest, and the sum of 150,000 naira being cost of garnishee proceedings. This court had the ex parte application on 26 October 2020 and granted same. On the 20th of November 2020, the judgment debtor applicant filed two motions, one for stay of execution pending appeal, and the other for an order vacating the garnishee order nisi. The judgment creditor respondent filed a counter affidavit to each of the applications on 30th November 2020. The first, second, and third garnishee each filed affidavits to show cause on 30th November 2020, 6th November 2020, and 23rd November 2020. On the 25th November 2020, this court, after hearing all parties in the garnishee proceedings, discharged the first and third garnishees and ordered the second garnishee to pay the sum of 5,765,944 naira 16 kobo into an interest yielding account in the name of the Chief Registrar of the National Industrial Court pending the determination of the judgment debtors' motions. On the 23rd June 2021, at the hearing of the two motions, the judgment debtors applicants counsel informed the court that the judgment of this court sought to be stayed has been affirmed by the Court of Appeal, whereupon he sought to withdraw the motion for stay of execution and same was struck out. Counsel also applied to withdraw prayer 2 in the motion seeking to set aside the order nisi, and the said prayer was struck out. The motion was argued only in relation to prayer 1, seeking to vacate the order nisi for failure of the judgment creditors to first seek and obtain consent of the Attorney General of Ekiti State before attaching the money of Ekiti State government. Case of the judgment debtors applicants. In an 8-paragraph affidavit deposed to by one Owoye Okoyemi, a litigation clerk in the Ministry of Justice, Ekiti State, his case is that SBJ Bamishe informed him that the judgment creditor failed to first seek and obtain the consent of the Attorney General of Ekiti State before attaching money in the control of the Accountant General of the state before commencing these garnishee proceedings. That the money garnished by the order nisi granted on 26 October 2020 is Ekiti State government fund. In his written address, learned counsel to the judgment debtors applicant submitted that this honorable court has no jurisdiction to entertain the garnishee proceedings because there is a fissure in the action which prevents the court from exercising its jurisdiction. That Section 84 of the Sheriff and Civil Processes Act requires that the consent of the Attorney General be sought and obtained before money in custody or control of a public officer, Accountant General of Ekiti State in this case. I put that in brackets, before an order nisi can be made attaching such monies. That the judgment creditors failed to first seek and obtain the consent of the Attorney General of Ekiti State before attaching money in the control of Accountant General of Ekiti State before commencing this garnishee proceeding. The consent of Attorney General of the State condition precedent before this garnishee proceeding and in this honorable court. There is no evidence before this court that the garniture judgment creditor sought consent of the Honorable Attorney General of the state before he secured an order nisi attaching the monies under the control of the Accountant General of the state. Counsel relied on CBN versus SCB number 1, 2015. Citation is fully supplied there. CBN versus J.I. Owanyao and Sons Enterprises Nigeria Limited. Citation is therein fully supplied. Central Bank of Nigeria versus Interstellar Communications Limited and 3 other citation is fully supplied, and Access Bank and another 2018 citation fully supplied. Case of the judgment. Yusuf Ishmael, you can actually off your mic. Case of the judgment creditor respondent. In a 15-paragraph counter affidavit deposed to by the judgment creditor respondent, the relevant paragraphs in view of withdrawal of prayer 2 by the applicant are paragraph 5, 6, and 12 to 14 as follows. That the paragraph 5, that the funds garnished belongs to the third judgment debtor, who was my employer, and not the Accountant General or any other public officer, and in the custody of Zenith Bank. Paragraph 6, that the order nisi was made against Zenith Bank, a commercial bank, and not a public officer. Paragraph 12, that the judgment debtor does not want to obey the judgment of the court out of malice. Paragraph 13, that the judgment creditor duly notified the Attorney General of Ekiti State via a letter dated 2nd January 2020 of his intention to enforce the judgment obtained by me on 18th November 2019 as required by law. A copy of the letter is herewith attached and marked as Exhibit B. Paragraph 14, that the Honorable Attorney General of Ekiti State consented to the enforcement by conduct. Of interest is paragraph 8 of the counter affidavit, wherein it was deposed that the appeal had been abandoned and there was already an application to dismiss the said appeal for want of diligent prosecution. A copy of the said motion, which is still pending, is attached as Exhibit A. In the said Exhibit A, filed at the Court of Appeal on the 7th of October 2020, the attached affidavit has the following depositions by the judgment creditor at paragraph 4A and B. Paragraph 4A says that leave was granted to the appellants to appeal on the 9th of June 2020. Paragraph B, that the notice of appeal was filed on 22nd June 2020 and served on the respondents' counsel on the same day. In his written address, Learned Kolapo Kolade of counsel to the judgment creditor applicant submitted that money in the hand of Zenith Bank will not qualify as money in the hand of a public officer. He cited CBN versus Interstellar Communications Limited 2008-7 Nigeria Law Report, Part 1618-294, that the legal requirement of the consent of the Attorney General before the attachment of government funds in the custody of the public officer is not to punish the government and adversary or to empower the Attorney General to override lawful order of court or to choose which order to obey or not by way of consent or otherwise. He also cited Federal Government of Nigeria versus Interstellar Communications Limited 2015 9 Nigeria Law Report, citation fully there. Christopher Onjeo and Kogi State Ministry of Commerce and Industry 2003, citation fully supplied. That where the Attorney General was a part of the proceedings, as in this case, his consent is no longer required. That in this case, the Attorney General, who is the second defendant, signed the notice of preliminary objection and the statement of defense. The case was conducted by officers of his department. In such circumstances, his consent is not required. He cited CBN versus Interstellar 2008 7 Nigeria Report, Part 1618-294. Counsel continued that the Attorney General was duly notified that the judgment creditor wanted to enforce the judgment as Exhibit B in order that the government is not embarrassed, and the Attorney General kept quiet and thereby consented by conduct, so the consent of the Attorney General is no longer required. The Attorney General received the notice since 3rd January 2020 but did nothing until a garnishee order nisi was granted on 26 October 2020, and the Attorney General waited until 20th November 2020 before filing a motion for stay of execution. Court's decision. The judgment creditor was a commissioner for justice in Ekiti State up to 15 October 2018. He was owed salaries, entitlements, and allowances amounting to 5,765,944 naira 16 kobo. This sum was acknowledged by the defendants, but the defendants did not pay because suit number NICN/AK05-2019. Judgment was delivered in favor of the judgment creditor on 18th November 2019. The judgment debtors appealed, and the judgment of this court was affirmed. The judgment creditor has attached monies belonging to the judgment debtors in satisfaction of the judgment debt on 27th October 2020. The judgment debtors want the monies released because consent of the Attorney General was not sought and obtained before attaching the judgment debt. The authorities are settled that the consent of the Attorney General ought to be sought and obtained before attaching monies in custody or control of a public officer, as provided by Section 84 of the Sheriff and Civil Processes Act, Cap 54 Laws of Federation of Nigeria 2004. It is also settled that monies in a bank is in control of the owner of such monies. See Central Bank of Nigeria versus Shuaib Budoma, 2018 LPLR 45639CA. See also United Bank for Africa PLC versus Access Bank PLC and another 2018 LPLR 44062CA. That's Court of Appeal decision. Contrary to the submission of learned counsel to the judgment creditor, the argument of the judgment debtors is not that Zenith Bank is a public officer, but that the Ekiti State Accountant General, who has custody of the said monies, is a public officer. Is a public officer, sorry. So the argument is Accountant General of Ekiti State is the person who has custody of the said money, and the Accountant General is a public officer. So the consent of the Attorney General was required. They never argued that Zenith Bank is a public officer. The courts have also stated the reason for Section 84 of the Sheriff and Civil Processes Act as to avoid embarrassment to the government. CCBN versus Njamanze 2015 Foreign Review Report, Part 1449, 276 at 287, where the Court of Appeal held. What then is the purpose of Section 84 of the Sheriff and Civil Processes Act? It is to avoid embarrassment of not knowing that funds earmarked for some purposes have been diverted in satisfaction of a judgment debt which the government may not know anything about. And that decision also cited Onjo and KSMCI 2013 Annual Report, Part 827 to 30 at 59. See also Federal Government of Nigeria versus Interstellar. Aderonke, please off your mic. Aderonke Akande, just off your mic. Just put off your mic. So see also Federal Government of Nigeria versus Interstellar Communications Limited, 2015, 9 Nigeria Weekly Law Report, Part 1463. Then the top Onjo versus Kogi State Ministry of Commerce. Now, the Court of Appeal, which has final jurisdiction on this case, has affirmed the judgment of this court. The judgment debtors are absolutely quiet about payment of the judgment debt. No arrangement and no proposal. Where lies justice in the reasoning of the judgment debtors? The essence of the law, it must be repeated, is the doing of justice. The court upholds the idea of passing judgment or ruling without doing justice. A correct judgment stroke ruling without justice defeats the aim of the law. If claimant against government obtains judgment in his favor, the government refused to pay him, and he has to seek consent of the same government before enforcing the judgment. sounds to me unjust. But that is my opinion and not the position of the law, which I have a duty to enforce. Section 237 sub 3 of the 1999 Constitution as amended. Oh, section 287. Section 287 subsection 3 of the 1999 Constitution as amended provides as follows. Enforcement of decisions. The decisions of the Federal High Court, the National Industrial Court, a High Court, and of all other courts established by this Constitution shall be enforced in any part of the Federation by all authorities and persons and by other courts of law with subordinate jurisdiction to that of the Federal High Court, the National Industrial Court, and a High Court, and those other courts respectively. Now, Section 84 of the Sheriff and Civil Process Act provides as follows. Consent of appropriate officer or court necessary if money is held by public officer or the court. Where money liable to be attached by garnishee proceedings is in the custody or under the account of a public officer in his official capacity or in custodial legis. The order NISA shall not be made under the provisions of the last preceding section unless consent to such attachment is first obtained from the appropriate officer in the case of money in the custody or control of the public officer or of the court in the case of money in custodial legis as the case may be. Sub 2 says, in such cases, the order of notice must be served on such public officer or on the registrar of the court as the case may be. Then sub 3 says, in this section, appropriate officer means A, in relation to money which is in custody of a public officer who holds a public office in the public service of the Federation, the Attorney General of the Federation. In relation to money which is in custody of public officer who holds such public office in the public service of a state, the Attorney General of the state. My first response to Section 84 of the Sheriff and Civil Processes Act would have been that it curtails the power of the courts as granted by Section 2873 of the Constitution as amended by subjecting the powers of the court to the consent of the Attorney General, a government and political appointee in a situation where the government is a debtor unwilling to pay, and so it is inconsistent with Section 287 sub 3 of the Constitution as amended. So Section 287 of the Constitution shall prevail, and Section 84 of the CPA shall remain void. However, no matter how strong the opinion of this court, no matter how this court is displeased with the state of the law, it remains a barren opinion. This court cannot hold according to its opinion above expressed. To so hold will amount to judicial rascality in view of the holding of the Court of Appeal per Muntaka Kumasi JCA on this issue in Onjewu versus Kogi State Ministry of Commerce and Industry 200310 Nigeria Report part 827 page 40 at 79, where my Lord held that Section 87 of the SCPA, that's Sheriff and Civil Process Act, is not inconsistent with the provision of the Constitution. I am not aware of any contrary position by a later decision of the Court of Appeal or the Supreme Court. This court remains bound by the decision of the Court of Appeal in Onjewu and Kogi State Ministry of Commerce and Industry by reason of the principle of stare decisis. The requirement of the consent of the Attorney General, like any other principle of law, is not a blanket rule without exceptions. In CBN versus Interstellar Supra cited by counsel, a case in which the Attorney General had participated in the settlement of the case, the court held that his consent was no longer required for garnishee under Section 84 of the SCPA. In this case, counsel to the judgment creditor submitted that the Attorney General was a party to this suit. He filed a preliminary objection and statement of defense in this suit, and also the case was conducted by lawyers from the Ministry of Justice. I agree that on the strength of CBN versus Interstellar Supra, the consent of the Attorney General is no longer required in such circumstances. However, it is unfortunate that as serious as these allegations of facts are, which in my view should form the strength of the opposition to this application, if they be true, these facts were not in the affidavit of the judgment creditor for the judgment debtors to respond to. They are only contained in counsel's written address, which cannot take the place of evidence. See Union Bank of Nigeria PLC and another Ayodare and Sons 2007 13 Nigeria report per 1052 page 567. Also unfortunate is the fact that the file is still at the Court of Appeal, Ekiti. If I had the file here, it is within my powers to look to confirm. But the file is at the Court of Appeal, Ekiti. So this court cannot speculate on facts relating to the participation of the Attorney General in the case. And the light went off. Okay, good, they have brought it. I think it's a switch over. This court cannot speculate on facts relating to the participation of the Attorney General in the case. See Mobile Nigeria Limited versus PAM 2005, Nigeria Report, part 657, page 506 at 527, Ogunye versus State, 1999, Nigeria Report, part 604, page 518. Another unfortunate feature of this application is the fact from Exhibit A of the judgment creditor that leave was granted to the appellants to appeal on the 9th of June 2020. And the notice of appeal was filed on 22nd June 2020 and served on the Respondents' Council on the same day. It is to be noted that the motion ex parte for garnishee order was filed on 30th June 2020 after the judgment creditor was duly served with a valid notice of appeal on 22nd June 2020. This fact was not disclosed to the court by the judgment creditor applicant, that is in the garnishee proceedings. Neither was it disclosed to the court by the registry of this court, who received the notice of appeal on 3rd September 2020, processed and transmitted the records of appeal during the pendency of this motion. It is clear that from 22nd June 2020, the Court of Appeal became seized of the matter. In the list, a garnishee order being discretionary, if the fact of a valid pending appeal was brought to the notice of this court would not have issued a garnishee order neither. But the judgment creditor withheld this information from the court. Learned Scholar Kokolade also argued that the Attorney General was duly notified that the judgment creditor wanted to enforce the judgment, Exhibit B, in order that the judgment is not embarrassed and the Attorney General kept quiet and thereby consented by conduct. So the consent of the Attorney General is no longer required. I have read Exhibit B, a letter of demand in respect of the judgment debt hearing. Paragraph 3 thereof reads as follows. We are therefore constrained to write this letter as a reminder that the judgment sum be liquidated forthwith, failing which you are also hereby notified of our intention to enforce the judgment under the relevant laws, and this we shall do without any further notice to you. Court holds the firm view that a notice of intention to enforce the judgment under the relevant laws does not amount to an application to the does not amount to an application for consent to garnish a particular account of the government in the control of a public officer. I take that again. This court holds the firm view that a notice of intention to enforce the judgment order under the relevant laws does not amount to an application for consent to garnish a particular account of the government in the control of a public officer. The letter, Exhibit B, is not a document contemplated by Section 84 of the SCPA. This is so because Section 84 of the SCPA did not talk about putting the Attorney General on notice, but it talks about obtaining consent of the Attorney General. This court is also of the view that even if Exhibit B amounted to such application, the silence of the Attorney General will only amount to withholding of consent. Accordingly, for all that have been said above, the application to vacate the garnishee proceeding succeeds and same is granted. The garnishee proceedings of 26 October is hereby set aside. 26 October 2020 is hereby set aside, and the other NISA made on 25th November 2020 is hereby vacated. This is the ruling of the court, and it is entered accordingly.
As
the court, please.
Yes, let me hear caller for.
My lord.
Yes.
There's nothing more to say.
But to say we thank the court, you have to thank me.
Yes, other than to thank
the court. You have to thank me.
Well, my lord, I thank you. I thank you. I thank you sincerely. We will explore the options.
That one is legally allowed hypocrisy. You may not be happy with the ruling, but you have to thank the court.
As the court pleases. We are grateful, sir.
Okay, Alabi.
My lord, we are very grateful for this sound ruling. It is a very remarkable ruling, and we thank my lord for the industry put into this ruling. We appreciate your lordship.
Because there is a judgment, the Court of Appeal has affirmed it, and you people are not saying anything about paying them. All you are interested is the money already attached should be brought back. So how and when are you paying them? So you know that even the court itself, its heart is bleeding by releasing this money to you because the law says so, or because I believe that is what the law requires of me. So we thank you very much.
Thank you, my lord.
Today is
okay. My lord, sir, may I make a humble application, my lord?
Okay.
So that we can get the ruling of the court as soon as possible, my lord.
Even today, you can get it.
As the court pleases.
As the court pleases.
We are grateful.
Okay, let's call okay, call the next one. Call the next one. Okay, Chief Tunde Ogunleye.
Respectfully, my lord.
Yes.
Kola Kokolade is my name. My humble appearance is for the judgment debtor. The judgment creditor responding.
You are also appearing for judgment debtor.
Judgment creditor, my lord.
Judgment creditor responding.
My lord, if you want to appear for us, we will not change our consent.
If you don't object, me, I will object because I have a duty to object. Okay, let's go. Announce your appearance.
With profound respect to this honorable court, Toluwani Alabi is my name. Senior Legal Officer, Ministry of Justice, Ekiti State. Our appearance is for the judgment debtor applicants. Most grateful, my lord.
Okay. The matter is for ruling. Ready?
My lord.
My lord. Yes.
Since the facts and circumstances are the same, maybe we should not waste the time of the court so that we take the judgment.
I said so even before we started, isn't it?
So that
it's just for formality. This is suit number NICN AK 12 2019, AK 15M 2019, Chief Ogunleye, Chief Tunde Ogunleye, Governor of Ekiti State, Attorney General, Access Bank, Zenith Bank, Fidelity Bank. This Honorable Court Oyewumi delivered judgment in this suit on 24th October 2019 in favor of judgment creditor respondent for the sum of 3.9 million and cost of 100,000. Judgment creditor filed a garnishee proceeding on 30th June 2020 for the attachment of the sum of 4,035,903 naira being judgment debt and the sum of 150,000 being cost of garnishee. All the remaining facts of the application are as in the other ruling already delivered. All the cases are the same. In my submission, in my considered ruling, I considered the same issues and came to the same conclusion. Accordingly, for all that have been said above, the application to vacate the garnishee proceedings succeeds and the same is granted. The garnishee proceedings of 27 October 2020 is hereby set aside and order NICI met on 25th November 2020 hereby vacated. This is the ruling of the court and it is entered accordingly.
As the court pleases. I'm not forgetting to thank my Lord this time.
Okay. Sorry.
We thank your Lordship, sir.
I'm even in a haste now that I forgot to. Colorful. We are grateful. Alabi.
We are grateful, my Lord, and we thank your Lordship for the industry in this ruling.
Thank you very much. For now, we only appeal to the conscience of the government to pay the judgment debtors, since the judgment of the court has already been confirmed by the Court of Appeal, which is the final court. Please pay them. Forget about the legal. Okay, the next one is Modupe. Appearance.
Kola is my name. My humble appearance is for the judgment creditor respondent.
Yes.
With profound respect to this honorable court, Toluwani Alabi is my name, sir. Senior Legal Officer, Ministry of Justice, Ekiti State. Humble appearance is for the judgment debtor applicants. I'm most grateful, my lord.
Okay. For ruling. The ruling is ready. This is the ruling of the court. Ruling, read, and enter. Okay. Suit number NICN/AK/13/2019, motion number NICN/AK/56M2020 between Dr. Mrs. Modupe Alade, judgment creditors, and the judgment creditor respondent, Governor Ekiti State, Attorney General Ekiti State Government, judgment debtors applicants, Access Bank PLC, Zenith Bank PLC, Fidelity Bank PLC, Garnishes. Ruling. Honorable Court by Oyo Media delivered judgment in suit number NICN/AK13/2019 on 24th October 2019 in favor of judgment creditor respondent for the sum of 7,454,185 454 184 and cost of 100,000. The judgment creditor filed a guarantee proceeding on 30th June for attachment, and then the court had the expert application on 27th October and granted same on 20th November 2020. The judgment debtor applicant filed 2 motions for self-execution pending appeal and the order for order vacating the order NICI. The same fact, the same everything in my ruling. I raised the same issues and resolved them just as in the other ruling that I have read. Accordingly, for all that have been said above, the application to vacate the garnishee proceedings succeeds and same is granted. The garnishee proceedings of 27 October 2020 is hereby set aside and order NICI made on 24th November hereby vacated. This is the ruling of the court and it is entered accordingly.
As a court.
Thank you, my lord.
Don't worry, don't worry. Thank you. Maybe it should be in my God's office, but don't worry.
Yes, Alabi.
We are most grateful for this sound judgment, my lord. We pray that the Lord will keep on directing your footsteps in writing such audacious judgment as this.
There is nothing audacious about this ruling, I'm telling you. If you listen to the tone of the judgment, there is nothing audacious. It is a ruling that is is according to law, not according to what the court thinks should be the justice of the case. So there is nothing commendable or audacious.
as a court, please.
Okay. Okay. 27. So that is all, gentlemen. You can come to court to collect your copies today.
Thank you,
As
my
a
lord.
court, please. Thank you very
Yeah.
much, sir.
Thank you, my lord.
Have a wonderful day, my lord.
Thank you very much.
And may I, with the kind permission of my lord, seek to leave the meeting.
Yes, you can leave.
Thank you, my lord.
My lord, I also seek your kind permission to
No
exit
problem. You
the
can leave.
noble
You
court.
can leave.
Thank you, my
The
lord.
case of Umar Diko Hassan, a Federal High Court of Nigeria. Okay. Okay. Please, counsels, announce appearance.
My lords, parties are not in court, sir.
Yes.
With utmost humility to this honorable court,
Yes.
my name is I.F. Yusuf.
Yusuf.
Yes, my lord.
Yes.
Appearing with me are K.A. Yusuf.
K.A. who?
Yusuf, Mrs.
K.F. Yusuf, Mrs.
K.A. Yusuf.
Mrs. now.
Yes, my lord. K.A. Yusuf. Mrs.
Mrs. Then
A.A. Omalabisa.
A.
Omalabi.
Okay. You are for?
We are for the claimant, sir.
All right. Who is appearing for the defendant?
May it please my noble lord.
Yes.
No matter.
The court.
My name is Yakubu Philemon.
Yes.
My lord, I appear with Dorcas May Samari. Dorcas May Samari.
Yes.
Our appearance is for the defendant, my lord.
Are you people private counsel?
We are private counsel, my lord. We will be briefed by the Federal High Court.
Okay. Okay.
Yes, my lord.
I thought I would hear your designation.
No, my lord.
Yes.
My lord
Yes,
is for
Yusuf.
adoption, lord.
My lord, the matter was slated for adoption of address.
Yes.
My lord, subject to the convenience of this honorable court, we are ready to proceed. The defendant had filed his defendant final address. Likewise, ours.
Ready to proceed. That's all. That's Ishmael talking, isn't it? Who is just talking now? Ishmael, isn't it?
Yusuf.
Yusuf Ishmael now.
Yes, my lord. That's I.F. Yusuf.
Yes. So let me hear Yakubu.
Yes, my lord. The defendant has filed his final written address, and with the subject to my lord's overriding convenience, we are ready to proceed, my lord. And we have also been served with the claimant's final written address, to which we are not replying.
That is good.
Yes, my lord.
So go on.
Respectfully, my lord, the defendant's final written address is dated 31st of March, 2021. But it was filed on the 1st of April, 2021, my lord.
Yes.
My lord, we adopt the said final address and rely on same as an argument,
The court to do what?
my lord.
And you urge the court to do what?
And we urge the court to dismiss the claim of the claimants in its entirety, my lord,
All right.
for their
Any
unfounded.
adumbration?
My lord,
Any adumbration?
my lord, by way of just simple adumbration, we will just say, my lord, that the dismissal, it is the case of the defendant that the dismissal of the defendant, of the claimant by the defendant was done in accordance with due process as prescribed by the conditions of service which bound both the defendant and the claimant,
Okay.
and that the claimant at every material point in time was a temporary staff of the defendant, and therefore his dismissal was done in accordance with the law. And that is the case of the defendant, my lord. We have canvassed
All right.
3 issues, and the issues are there, my lord.
Thank you very much. You are welcome. Yusuf?
Yes, my lord, sir. My lord, our final written address was dated 18th day of June 2021.
No, what is mentioned that?
And filed
But filed on the 21st June 2021.
okay.
My lord, we seek to place reliance on all the arguments therein,
Yes.
and we want to adopt same as our argument in this matter.
So it's not time to want to adopt it. That's why we are here
We
today.
my lord, we adopt the argument contained in the written address, sir, as our argument, sir. Thank you, my lord.
Yes.
My lord, we hold this honorable court to grant all our claims as meritorious.
All right.
We are so much grateful, sir.
Any word or words in adumbration?
Everything is contained in our. Thank you, sir.
Thank you. Okay.
Thank you, sir.
Sola, when are we resuming? It's a lie. Don't tell me things from your head, Shola. Don't tell me things from your head. We are resuming 20 September, maybe 27 or 26. We will take this judgment in September. Immediately we resume.
As court places.
Even if I'm not here in Akure, I will deliver the judgment in Jos.
As the court said,
I am not here. I'll deliver it at the from Jos. That's the beauty of it.
As the court.
Yes. Deliver the judgment.
Unproductive vacation, my lord.
Thank you very much.
My lord, we wish you the best, sir. Thank you, sir.
So we will take the judgment on 28th September.
As
completed.
By Zoom.
Yes, my lord, sir.
It is by Zoom.
We are most grateful.
So
Yes,
on that day, if you don't get notice of an official Zoom ID, you will use my personal Zoom ID, which you already have. I'm sure.
Thank you, sir.
it is also official. The one we were using initially, do you have it?
Yes.
No.
Now,
The
so
one
that
that
we'll
was
post it for you. So that we'll post it for you right here. You have the old
Thank
IC
you.
that we were
Thank you.
using. Eh?
Okay.
Okay, we didn't get it matter by Zoom. So you won't even, okay. Take it down, take it down. Please, council, take down the alternative Zoom something. If
Yes, sir.
on that, okay, no. Shola will text it to each of you because we are in public.
Okay, sir. Thank you, sir. Thank you, sir.
Signal something to you now. So if you don't
Okay.
get any notice from NICN before that day, you will use what Shola will text to you now.
Thank you, sir. Yes, sir.
Thank you,
Thank you, sir.
All right. Thank you. 28 September 2021 for judgment.
As copies.
And I think that is all for the Zoom sitting.
No, my lord.
Yes,
My
they
lord.
are public. Which one is this one? Which one?
May I seek leave to leave the meeting, sir?
You are permitted, sir.
Thank you, sir.
Is this your matter not supposed to be physical? What is the matter for? Is it Aderenko or yes?
I don't care for them, my lord. We prefer
Yes,
respect.
the matter is supposed to be for what?
My lord, we got the notification from the registrar that the matter is adjourned to today and via Zoom.
Is for what?
My lord, the last adjournment, the claimant counsel was not online. So my lord directed that after Justin strike, we will get a date for physical hearing. So it was later we got a note when I called to follow up that Mr. Shola informed me that the matter is for via Zoom.
So the matter is for hearing of evidence.
My lord, pleading has been closed, is being closed because we never, the claimants have never filed any response to our defense.
We will not give you one. Just, is my question too difficult that you have to explain your answer? Don't explain your answer. Just let me know. So Audra, the matter is for what? It's for hearing of evidence.
Yes, my lord.
Hey, now, it's simple something.
My lord, I just want to be corrected, my lord. I was thinking that there will be a CMC before trial.
That there will be a what?
CMC, case management conference, my lord.
If you people want a case management conference, you people will arrange that one with the divisional registrar.
As the court pleases.
Case management conference for what now?
I was thinking.
So that what will we manage?
As the court pleases.
What will you manage at the conference?
We learn every day, my lord.
Or maybe is it a mandatory procedural requirement by our rules?
That's why I'm asking, my lord. That we learn every day. I'm well.
You are asking me to tell you what our rules require. It is your duty to study our rules and know what is required.
As the court pleases, my lord.
Yes. So the matter is for anyway. Let me take your appearance.
As the court pleases.
Yes. Number 3. Your appearance now.
With proper respect to this honorable court, Aderonke Akonde.
Yes.
For the defendants, my lord.
You are with somebody.
Yes, my lord. With me, my lord, is Mimido Inyev. Miss.
Mimido.
Mimido Inyev. NYIEV. NYIEV, my lord.
NYIEV.
Yes, my lord. Miss. For the defendant, my lord. We are most grateful.
Mimido. Yes. Okay. Like me,
Yes,
I'm not in this Nigeria. So that name is from which part of Nigeria?
yes, we're plenty.
My lords, I'm from Shandan local government.
Hi, Haba. Hey, Haba. Mimido, EF.
Yes, my lord.
So, you see how much lost I am? You are from Plateau State.
Yes.
Yes, sir.
Shandam local. So this name is which language? EF.
Is Tarok. My mother is from Tarok, sir, and my father is a Benue man. So it's a combination of the two tribes.
The EF. Because I
Yes.
actually suspected this EF. The nearest I was suspecting is either Chief or Idoma.
No, it's Steve.
Uh-huh. Okay. All right. Thank you very much.
We're
At least that
almost
is some information for me. It's all right. Yes, who is for the claimant?
My Lord, SV Ajishomo is for the claimant, but I was surprised it's not on.
Oh, okay, claimant counsel not in court.
Yes, my Lord. It appears it's not in court, my Lord.
All right. Sorry, it's supposed to be for physical hearing. Actually.
All right, my Lord.
You are for the defendant.
Yes, my Lord.
Okay, okay. I can see your statement of defense now. So you
Yes.
were like complaining something was missing. Nothing is missing now. There's a statement of claim. There's a statement of defense. We have discarded of all the motions.
Yes, my Lord.
Yes. Yes. So it's for, I think it's error of the court registry that they put it on Zoom. It's supposed to be for physical hearing. And it's apparent they didn't even serve the claimant counsel.
My
You
Lord,
did?
with time partition of the court, we, in our list of documents, at the time of
Yes.
filing, we couldn't get our hand on some documents, which we pleaded.
Yes.
And we intend to
Yes.
file additional documents as soon as
Instead
possible.
of telling me your intention, simply do what you ought to do.
As the court pleases, we intend to do
Please
that as
don't delay about it. Don't, it's just additional document. It's
As
a
the court
very
pleases.
simple process, isn't
As
it?
the court-
As long
Very
as
well.
it was
As the court-
mentioned in the pleadings or probably even listed.
As the court pleases.
Just
We are
bring
most-
your application. I
We will do
pleaded
the
this document in paragraph this, or I listed it here, but I omitted to attach. They are hereby attached. Simple.
As a couple, we are
Okay.
most grateful, my Lord. We are most grateful, my Lord.
Okay, this case is adjourned to 21st October 2021 for physical hearing.
As the court pleases.
Claimant counsel to be served. Thank you very much.
We are most grateful, my Lord. Thank you, my Lord. We wish my Lord a restful and a peaceful vacation, my Lord.
Zoom. And I asked you in court, you said 3 matters. I come now, it's 6 matters. No, wow.
My Lord, permission to exit the Zoom meeting, my Lord.
Please, you are permitted.
Thank you, my Lord. We are most grateful.
I was wondering when the registrar informed us that it will be registered.
Mr. Fabun Mile Oluwani and 7 others versus Nigerian Union of Agriculture and Allied Employees and others.
I know it's
Who
going
is
to
in this matter? NICN/AK/29/2030. Who is in the case? No, God, they are not. Maybe the defense counsel must have called him. Give me a date.
21st.
Is it for physical hearing?
No, it's after it's supposed to be right.
Oh, what?
I don't know. I don't know. They moved all this commission. And it's an originating song of broken.
Physical hearing. Hearing notice to issue on parties. Then we will come that day. You have served one party and not the other, or you have not served. Okay, parties, no appearance for either party. Case adjourned to 21st October 2021 for physical hearing. Hearing notice to issue on parties. That's all. Now that is all for the Zoom meeting today. We will all leave. Thank you.